For 91 long years, the National Firearms Act has shackled the rights of Americans, forcing citizens to pay burdensome taxes, beg the government for permission slips, and register themselves like criminals just to own a firearm with a short barrel. Nearly a century of infringement, nearly a century of bureaucratic strangulation, and nearly a century of being treated as second-class citizens simply for exercising a constitutional right. But today, there is groundbreaking news that changes everything. This is history in the making, and it is happening right now. Franklin Armory has broken through the walls of the NFA. This is not a loophole. This is not a clever workaround. This is a full, court-backed, ATF-acknowledged exemption from the law that for generations has robbed people of their freedom. This is victory, plain and simple, and it is a massive win for the Second Amendment. What we are talking about is the Antithesis, a brand new class of shoulder-fired firearm with a rifled barrel under 16 inches and an adjustable shoulder stock. This firearm sits completely outside of the NFA. It is not covered, it is not restricted, and it is not subject to the suffocating rules that so many Americans have been trapped under for decades. That alone should make every patriot stand tall today. But don't think this was luck or a quick fix. It took 8 years of litigation, 19 separate motions, 2 federal district judges, and more than $1 million in legal expenses to achieve this. 8 years of relentless fighting, standing toe-to-toe with the federal government, battling over definitions, interpretations, and bureaucratic overreach. And Franklin Armory did not flinch. They pressed forward until the courts finally admitted the truth. For context, remember this: the National Firearms Act goes all the way back to 1934, and the Gun Control Act dates back to 1968. Together, these laws have defined what the government calls short-barreled rifles and short-barreled shotguns. For decades, they've controlled who can own them, how they must be registered, and how much extra money citizens must pay just for the privilege of exercising their rights. Franklin Armory said enough is enough, and they brought the fight to the ATF in federal court. And now, after years of resistance, a federal judge has ruled in their favor. So, what exactly is the Antithesis? According to Franklin Armory, it begins shipping today in 6 different variations. Chambered in 5.56, it features barrels as short as 7.5 inches, stretching up to 12.5 inches. All of them carry the same crucial advantage: they are not under NFA control. No 200 tax stamp, no Form 4, no fingerprints, no ATF notification just across state lines. No federal registry with your name and your serial number, no endless waiting, no government permission slips. Instead, the Antithesis transfers like any other standard firearm on the common 4473 form. That is freedom restored, that is liberty reclaimed, and that is the victory we've been waiting for. Why is this possible? Because the law itself defines a rifle as a firearm designed to be shouldered that fires a single projectile through a rifled bore. Franklin Armory deliberately designed the Antithesis to fire both single projectile cartridges and multiple projectile ammunition. Think .45 long Colt, think .410 shotgun shells, think duplex rounds, even snake shot. Yes, even that. The kind of ammunition the bureaucrats never thought would fit into this definition. And yet here it is, running through the Antithesis. That design pushes it completely outside of the statutory box they tried to cram it into. The law's own wording was turned against them, and the ATF had no choice but to throw up their hands and admit defeat. The federal judge made it crystal clear in his words. He said, and I quote, "The Antithesis is a square peg, and calling it round will not change how it fits into the round hole of these statutes." That one statement sums up the entire victory. They tried to force it into a category that didn't apply, and the court would not allow it. This ruling does not just stop at the Antithesis, either. It also corrected years of misclassification by the ATF when it came to another Franklin Armory creation, the Reformation. The Reformation is unique because it uses a barrel with straight lands and grooves. It is not rifled in the traditional sense, so it does not impart spin to a projectile. But it is not a smooth bore either. It sat in a gray area, not a rifle, not a shotgun. Yet the ATF forced it under NFA control anyway, stretching definitions far beyond what the law ever intended. That injustice has now been overturned. The court vacated that classification, and the Reformation is back on the market. Just like the Antithesis, it transfers on a standard 4473 form. No extra tax, no registration, no fingerprints, none of the baggage that the NFA drags along. But this story gets even bigger. After the President's 2025 executive order titled Protecting Second Amendment Rights, Franklin Armory joined forces with FRAC, the Firearms Regulatory Accountability Coalition. Together, they pushed forward a conditional settlement with the Department of Justice and the ATF. That settlement codified on a nationwide basis that the Antithesis is not a short-barreled rifle, that the Reformation is not a shotgun, and that neither firearm can ever again be regulated under the provisions of 26 U.S.C. 5845. These weapons are completely immune from the short-barreled rifle and short-barreled shotgun clauses of the Gun Control Act. That is not just a local win in one circuit. It applies coast to coast, in every state, binding the ATF by order of the court. And how do we know? Because the ATF was forced to publish a brand new open letter confirming it. I have it right here, dated August 29, 2025. It is addressed to all federal firearms licensees across the country. The subject, the Franklin Armory Reformation and Antithesis firearms. This was not a small memo tucked away in a drawer. It was an official, public, open letter acknowledging the truth. That letter rescinds the earlier open letter from December 19, 2019, the one that wrongly classified the Reformation. Back in 2019, the ATF's Firearms and Ammunition Technology Division had examined the Reformation and claimed it was a shotgun subject to the Gun Control Act. They said that if it had a barrel under 18 inches, it would be considered a short-barreled shotgun under the NFA. And for the Antithesis, the same division classified it as a short-barreled rifle. All of that is now null and void. The 2019 letter has been vacated. The 2025 letter replaces it. And the truth is finally on record. The new open letter spells it out plainly. The Reformation is not a short-barreled shotgun under 18 U.S.C. 921A6. It is not a short-barreled rifle under 18 U.S.C. 921A8. It is not a firearm under 26 U.S.C. 5845A. And therefore, it is not subject to the requirements of 18 U.S.C. 922A4 or 922B4. No NFA paperwork is necessary to sell it, transfer it, transport it, or possess it. No ATF Form 532.20 is required to carry it across state lines. It is not an NFA firearm, period. The Antithesis receives the same treatment. The open letter says directly the Antithesis is not a rifle, not a short-barreled rifle, and not an NFA item. Therefore, no NFA forms are necessary for it either. No tax, no registry, no file, no interstate permission slips. It is free from the very regulations that for decades smothered innovation and strangled liberty. The letter even gave instructions to every federal firearms licensee on how to handle sales and transfers. When dealing with the Reformation or the Antithesis, licensees are told to use the other firearm box in Block 24 on the ATF Form 4473. Not rifle, not shotgun, but other. That simple checkmark represents a monumental change. It is the government's own acknowledgement that these firearms do not fall into the categories they once tried to force them into. It is the clearest signal yet that the tide is turning, that the NFA is not untouchable, and that the courts can and will put the ATF back in its place. Now think about what this means for everyday Americans. For the first time in nearly a century, we have access to short-barreled, shoulder-fired firearms without being treated like criminals. No more begging for permission to take a gun across state lines. No more fingerprints. No more months of background delays. No more names entered into a federal registry that never should have existed in the first place. For the first time, liberty looks like it should straightforward, unburdened, free. And this case is bigger than just one firearm. It sets a precedent. It proves that the NFA can be beaten in court. It proves that judges will hold the ATF accountable when they exceed their authority. And it proves that innovation, combined with determination, can restore freedoms the government thought it had buried forever. Of course, people can still go through the NFA process if they want. You can still buy a short-barreled rifle or a short-barreled shotgun under the old system if you choose. You can pay the $200 tax. You can file the paperwork. You can wait for the background checks and fingerprints. You can jump through the hoops, but why would you? When on January 2nd, 2026, that $200 tax is scheduled to be dropped entirely. And why would you, when Franklin Armory is licensing the Antithesis technology to other manufacturers and importers? Soon, companies across the country could offer short-barreled versions of your favorite rifles, all exempt from the NFA. That is how freedom spreads. That is how in common use gets established. And that is how restrictions crumble. This is not the end of the battle. Franklin Armory has said clearly they are not stopping here. More lawsuits are in motion, aimed squarely at what remains of the NFA. And with this precedent, with this momentum, there is every reason to believe those lawsuits will succeed. Every success chips away at the unconstitutional foundation of laws written in the gangster era, laws that never belonged in a free society. So where do we go from here? We support the fighters who stood up when everyone else said it could not be done. We educate our neighbors, our friends, our communities, because most people have no idea what a short-barreled rifle even is, let alone how it has been restricted. We spread the word, we stay engaged, because liberty does not advance by waiting for politicians. It advances through innovators, patriots, and citizens who refuse to accept unconstitutional restrictions. The Antithesis and the Reformation are not just firearms. They are proof that the American people can win back freedom. They are proof that the courts can check government power. And they are proof that determination works. So carry that forward. Share this news. Talk about it. Use it as fuel to push until the NFA itself is nothing but a footnote in history. This is just the beginning. Be safe, stay vigilant, and keep carrying to protect yourself, your family, your community, and your country, because the job of safeguarding liberty will never belong to the government. It belongs to us. And with victories like this, we are proving that freedom can and will prevail.